Welcome to my channel, All for Health with Jane. Family, we are still on the Senzo Meyiwa trial. The issue of accused number 3 of being kept in solitary confinement is still a serious problem. This issue started even during the time of Judge Maumela, who advised Advocate Defo, saying that they must open a case against the correctional service. Now, in this case, we having Judge Rata, who is today reporting to the court that he took this matter of accused number 3 to Judge Cameroon, who is the Inspector of Prisons, and to Judge President Mlambo. And now in this court, Judge Rata is reporting back to the court about what the two judges said. Family, let's watch and listen.
Yes.
As the practice was, when we adjourned just before the recess, Advocate Ramasipili had just completed his cross-examination.
Yes.
However, before we adjourned, Advocate Municipal raised the issue of his clients who's being held in solitary confinement. The court undertook to liaise with Judge Cameroon, the Inspectorate of Prisons.
Fine, I'm aware of it. Okay. At the last hearing, Mr. Advocate Nisi addressed the court on the basis that his client has been unlawfully detained, in the sense that he spends only 1 hour out of the 24 hours where he could say that is his own time in prison, where he's allowed, supposed to have exercises, etc. Mr. Minister also complained about the fact that he sometimes cannot have the opportunity to consult with his client. So the last hearing I undertook to speak to Judge Cameron. I didn't do it because when I told the JP Mlambo that I intended approaching him in connection with your client's complaints, he told me that Cameron judge had already written a letter to him. In that letter, they were discussing, amongst other things, the fact that judges of the high courts, when they make orders which proclaim accused persons who are there who are detained pending them being certified to be compos mentis, meaning that they can stand trial. But before they do that, a psychologist, psychiatrist, or doctor must examine that type of person. And normally the judges only make a blanket order that the accused person is referred to Sterkfontein or whichever hospital, mental hospital or vet copies or whatever. And sometimes in the system, the accused persons are never again visited upon by the psychiatrist. So Judge Cameron was complaining that these persons fall through the cracks because their detention is not defined. And he was insisting that maybe judges should make orders defining exactly that this 90-day period, what should happen to it. And preferably an order which is justifiable to detain this person for mental examination should be about 90 days, but within 90 days or at the end of 90 days, that person should again be seen in court by a judge who will then determine whether in fact this person is being treated or not. Judge Cameron also made mention it's public knowledge that he believes that some of the detentions are, as he puts it, are inhuman in the sense that they do not have consideration of the constitutional rights of some of the prisoners, and that sometimes the Bill of Rights is being compromised in that fashion, in that they are not given enough time to go and exercise, they are not accorded time to be visited by their loved ones or relatives or wives, and that he thought that exigency should be visited upon by the Department of Correctional Services, which apparently he did. And J.P. Mlambo, when I discussed that there is this complaint about the human rights pertaining actually to the detention or the confinement of awaiting trial prisoners, or there are certain complaints which have been visited upon, for instance, by Mr. Mnisi. The JP's view, which I agree with, is that this is a comprehensive question of the alleged infringement of the Bill of Rights, and he cannot alone, because there are 5 or 6 or 9 divisions of the Supreme Court, of the High Court here. It must be a general dispensation which is accorded by the Director of Public Prosecutions. So, concerning Mr. Mnisi's client, I did a bit of research, and I came across this case. The Minister of Justice, Correctional Services and others versus Ntuli and Judicial Inspectorate for Correctional Services as amicus. I'll give you a copy of this. This case was finalized on the 13th of September 2023 by my brother Anta Halter. He was sitting with 4 other judges. And this case, I think it's the most comprehensive decision in South Africa concerning the Bill of Rights as it pertains or affects so-called prisoners or persons who are detained. If you read this case, you'll be able to find your way how you must approach the question of your client. Okay. Hello. It pertains only to that one. It pertains only to a so-called accused person or prisoner who wanted to exercise his rights to study, and he wanted to be accorded the right to have a computer which he must utilize for his studies. But it traverses the Bill of Rights pertinently as it pertains to persons like your client. The only way you can visit that exigency is to bring an application to court, as suggested by Mr. Baloyi, which will have to define your client's rights pertaining to his incarceration, confinement, study, or exercise, visitations by friends, accused persons, or parents, etc., etc. So your only option, because when I read that decision, apparently it accords with what Mr. Ngumalo was telling Baloyi and yourself about the fact that apparently your client is alleged to be, I don't know, a security risk, whatever they mean by that. So you have to bring an application. There is no other way you can do it, because the Director of Correctional Services is the one who frames these regulations which control the incarceration of persons or prisoners, either awaiting or trial or those who are already sentenced. Okay. That's all I can tell you.
As it pleases the court, my lord, I'm indebted to the court, and thank you very much.
Okay, thanks.
I'm not so sure whether I need to get a directive from Mr. Mlambo.
Yeah, you'll tell him what the law says and what that judgment pertinently says. That's the only judgment in South Africa.
Yes.
Concerning a Bill of Rights, concerning what your client complains about, amongst other things. Okay.
Yes. I'm not certain whether I can also request that what the court has just alluded to be interpreted to him as well.
Okay, fine. Mr. Interpreter, are you listening?
Yes, my lord.
Yeah,
but
fine.
It was a bit long,
Yeah, okay. No, the salient parts of it.
as the court places.
Family, maybe it's high time that Advocate Mnisi must listen to Judge Rata and take this matter forward. This is an issue that cannot be dealt with in this court, but instead, accused number 3 needs to open up a case against the correctional services. Correctional services must be brought to the court as a new case altogether. Maybe they need to try that because remember, family, even Judge Maumela gave them the same advice. Judge Maumela gave Advocate Tefu the same advice. He didn't do that. Today it's Advocate Nisi. Judge Rata is giving him the same advice to say this issue, it's an issue that cannot be dealt with in this case. So let's hope Advocate Mnisi assist accused number 3 to resolve this matter. Family, thank you very much for watching this video to the end. Please like it before you leave. Subscribe for my channel if you haven't done so yet. I love you, family. Thank you. Bye.